Good morning, Steve Armstrong here. I'm an attorney at Armstrong and Peake in Louisville, Kentucky, and I'm coming to you today with a video on what you need to do with certain forms when you first start a case. I mean, like day two, day one, day two, at least the first 7 days. And the first thing you need to do is launch your investigation, of course, but specifically, I want to talk about forms today. The Form 106 medical authorization is probably one of the first things you want to get or obtain, signed, dated, witnessed, and with the Social Security number and all the blanks filled in by the employee, the claimant, on day one, if possible. Other states don't necessarily give you the right to a Form 106 medical authorization. This is a HIPAA release form. I'm going to be clear. They don't give you that right until later. But in Kentucky, you had the right to investigate the claim from day one forward. And part of that investigation is the actual Form 106 medical authorization. You can find this, I believe, on our website. You can find this through the Kentucky Department of Workers' Claims website. And it's probably already in your packet, but I want to elaborate on why you want this. Specifically, if you need prior medical records, let's say somebody had a back injury 3 years ago that you need to find out about, you need to learn more about and obtain those medical records, you've got to get a Form 106 medical authorization or some other HIPAA release form. But the Form 106 is the state mandated, state authorized form. It's supposed to be the form that medical providers will comply with because the state puts it out there. And so sometimes they do, sometimes they don't, but at least you've got a running start if you have a signed, dated, completed Form 106 medical authorization. There's something else in here as well. What do you do if the employee won't sign it? What if they refuse? With the form itself, right on the form, it says, in as much as the statute KRS 342.020 requires a medical waiver be executed, revocation may result in suspension or delay of the workers' compensation claim. And so the point is, if they won't sign this thing, you have a good faith basis probably to deny the entire claim because they're impeding your ability to perform an investigation. Now, if the claimant had a massive truck wreck and they're in the hospital, they can't sign it, okay. But you still have the right to this form. That's my point. And if you are concerned about how to deny something or how to ramp up and tell the employee that they need to sign this thing, seek your attorney. If it's not me, ask your attorney about it. But and again, any denial of any claim has to be in writing all the time, forever. Okay, so the Form 106, you're entitled to it first week, first day, really, of the injury. Some employers even know to ask the employee to sign it on the day of the injury. Okay, and then the statute that authorizes this is KRS 342.020. You can find that on the internet or in the Kentucky Department of Workers' Claims website. Again, if you're going to deny it because they won't sign it, they won't do anything, you have to put that in writing. The second thing you need to do is ask for a Form 113. And what is a Form 113? A Form 113 is the form that designates the gatekeeper physician. I'm looking at one here. You can find these on our website, but you can also find them on the Kentucky Department of Workers' Claims. At the top, it has the employee. The employee is supposed to fill this out and then have their doctor fill out and sign part of it as well. And then they're supposed to return it to you. Pardon me. So the whole point of this is that the employee has the right to choose a physician, and then they are supposed to designate who that gatekeeper physician is. All referrals are supposed to come from this gatekeeper physician. It lists the date of the injury. It lists the first designated physician. The employee can change the Form 113 one time, no questions asked. But the third gatekeeper physician, they have to come through you. You have to agree to it, or they have to get a judge to allow it, one or the other. The whole point is to avoid doctor shopping. I say this in the context that I had a claimant a few years ago who had gone through 20 doctors. He had lived in the southern part of the state. He'd gone through 3 or 4 there, but then he he spent half his time in Florida. He was fortunate enough to be able to spend half of his year in Florida, and he would go to various doctors down there who were not part of the gatekeeper physician, who weren't referred to from the gatekeeper. So we filed a medical dispute against those because you have to once it's a litigated claim, and this is post-award, post-settlement. And so the judge basically said, Mr. Claimant, you can go to these doctors, but the employer does not have to pay for these doctors. He basically said, Mr. Employee, rather, you can go to all 10 of these doctors if you want to. But the question is, does the employer have to pay? And the judge said no. And this is supposed to be like a spoken wheel scenario where all the referrals come back to this gatekeeper physician. In other words, if let's say this is a general practitioner who refers it on to a orthopedic surgeon who then refers it on to a pain management doctor, that's not supposed to be the way it works. Now, in reality, does that happen? Often, yes. There's also times where plaintiff's attorneys will intentionally list two different doctors for two different body parts that were injured on the same day. I resist that to the extent possible. What happens if, and I'm reading here from the regulation, which is also something you need to read. The regulation is 803 KAR 25:096, selection of physicians, treatment plans, and statements for medical services. If you're working with an employer, if you're a claims representative who's doing Kentucky workers' compensation law, the first thing you need to do is read this regulation. Again, it's 803 KAR 25:096. That is the absolute first thing. If you don't read that, you're missing out, because this is the playbook for employers, for claims representatives, for attorneys, and for judges, really. But Section 2 of this says that the employer has the obligation to supply a designation of physician within 10 days of the work injury or occupational disease causing lost time. Even if it doesn't cause lost time, you should do it anyway. And you're supposed to send it by mail to the employee with a self-addressed stamped envelope. Remember, a lot of these regulations were written in the 1990s when not everybody had email. Now, can you send it by email? If the employee will send it back, great. But not everybody has a scanner. So this regulation says that you have to mail it to them, and with a self-addressed stamped envelope. Then it says failure by the medical payment obligor. That means you. Medical payment obligor means whoever's going to pay the bill, which is the insurer, self-insured employer, third-party administrator. Failure of you to mail the form shall waive an objection to treatment by other than a designated physician prior to receipt of the employee of the form. So you got to mail it, and with the self-addressed stamped envelope. Then it turns back on the employee. The next provision says that the employee shall give to the medical payment obligor the identity of the designated physician with the tendered Form 113 within 10 days after the acceptance after treatment is commenced by the physician. So you get 10 days to get it to them. They got 10 days to get it back to you. What happens if they don't fill this out? Well, first, you got to have this in writing, in paper, to make sure that you sent it to them and that they know that they needed to do this. If not, then you can't really move to compel or suspend their benefits, because I want you to have the best evidence possible, the best proof possible that you complied with the regulation first. But Section 3, subsection 5 says that the unreasonable failure of an employee to comply with the requirements of this section may suspend all benefits until a compliance by the employee occurs. So you can, again, write them a letter and say, hey, Miss Claimant, I haven't received your Form 113. You owe me that designation of physician until I get it back from you, signed, completed. I'm going to suspend your benefits. If you're going to do that, you need to do that in writing. And again, if you've got any questions about that, ask your attorney. If it's not me, ask whoever that is. Okay. The third one is the Form 114. And I don't know if you've seen this or not, but this is the request for payment for services or reimbursement for compensable expenses. My clients, my main clients, send all three of these forms out day one or day two with a cover letter that says, hey, here's these forms. You got to send the Form 106 and the Form 113 back. With the Form 114 for any out-of-pocket expenses or mileage, you need to send that to us every 60 days. And that's exactly what this is for. Copays. You're not supposed to have copays in workers' comp, but you know how that goes. Your mileage, all mileage to even physical therapists to doctor, it's all reimbursable under Kentucky law. And what I see sometimes is that the employee will not know about this, not do anything about this. And 2 years later, they'll hire an attorney. And then the attorney will say, well, tally up all your mileage. We're going to submit it. And then you get a bill for $1,000. Not fun. The whole point is the plaintiff is supposed to keep this current for you, and so that you can reimburse them on a timely basis every 60 days. And what you want to avoid is, I have seen a couple of cases where, and there's a reported case where, you know, the employee or the employee say it didn't file these, didn't fill them out, and then waited years later, and boom, out of the blue, the employer gets a bill for a few $1,000s, more than $1,000, you know, like $3,000 or even more than that in one reported case I saw. You want to avoid that. You want to keep these people current for your sake, not just for theirs. So these are the things that you need to do the first week of any case is the Form 106. Get that back from them. Get the Form 113 signed back from the employee. Remember, the employee has the right to choose physicians, right to choose pharmacies. This is Kentucky. It's a populous state. So there's a lot of employee-friendly provisions here. The Form 106, you know, some of these hospitals will not abide by it, but you have the duty to try and get the records through the Form 106. And then if that doesn't work, then you can say, hey, judge, or hey, claimant, I need you to sign this Baptist or this Norton specific release form, because they won't honor the Form 106. And then the Form 106 is supposed to be, let me back up. The statute says that the statute actually requires medical providers, hospitals, doctors to provide the medical records within a reasonable time frame. What is reasonable? Well, HIPAA, federal law, says 30 days. So, you know, that's my view on what is probably going to be deemed reasonable by a judge in Kentucky. And okay, so if you have any questions about the Form 106, about the Form 113, about the Form 114, or process, feel free to call me or email me. Let me know. Hope this helps. Thank you. Bye-bye.